Knowing your consumer rights, super important, but especially when it's under the Arizona lemon law, something I was unfamiliar with, and that's unfortunately when you're saddled with a lemon. So Shalev Amar with Amar Law Group is here with us today. How are you doing?
Doing great. How are you?
So good. People not so good, those who are saddled with a lemon. So can you explain what the Arizona lemon law is for our viewers?
The Arizona lemon law is basically a warranty enforcement statute. So it's meant to help you out when you've bought a brand new defective vehicle that keeps breaking down over and over again or is in the repair shop for way too long.
Okay, certainly, vehicle breakdown's not good, but when is a vehicle considered a quote-unquote lemon?
Well, that's a bit of a complicated question, but I'll give you the Cliff Notes version.
Okay.
There's no specific number of attempts or time in the repair shop that's considered a lemon. The lemon law does have what are called presumptions. So a presumption is not a requirement, but if it's met, it shifts the burden of proof to the other side, so it's very helpful. So one of the presumptions is 4 more repair attempts for the same substantial problem, and it continues to exist. The other presumption is 30 or more days in the repair shop. But again, those are just presumptions. In our view, if you have 3 repeat repairs for a substantial problem, that would qualify as a lemon. If you have 25 or more days in the repair shop under warranty, that would also qualify as a lemon.
I think those are good underlying bullet points. But what is the coverage period then, or the time limit maybe for asserting a lemon law claim if you've already gone through those hoops?
That's super important to know, because one of the most common reasons why people can't assert a lemon law claim is because they're timed out. So in Arizona, the lemon law period is the earlier of 2 years or 24,000 miles. So whichever happens first, that's the maximum time limit. So that means, let's say you have 20,000 miles, but you've hit 2 years.
Sure.
That's the lemon law period. If you hit 24,000 miles in, say, a year and a half, then that's the lemon law period. Now, once you hit either one of those factors, then you have 6 months to assert a lemon law claim.
Okay, so that 6-month window is very important. What about what consumers maybe can do to recover under the Arizona lemon law itself?
So there are 3 main resolution options when you assert a lemon law claim. The first 2 are expressly written into the lemon law statute. And the third is basically what's available as a compromise. And as you know, when you settle a case, you're compromising. In most cases settled. 95% of our cases actually settle out of court. So first, you could get a lemon law buyback. The way a lemon law buyback works is they pay you back all of your payments. They'll pay off any outstanding loan balance minus mileage. Now, mileage can't be 0 because it's written into the law, but we do try and negotiate that as low as possible because it's reasonable mileage. So in the context of settlement, it's what both sides agree is reasonable. The second option is what's called a new vehicle replacement. The way that works is sticker price to sticker price. As long as the sticker price is the same or lower, the consumer is not charged anything, but it's got to be by the same brand as the manufacturer. It doesn't have to be the exact same model, but it does need to be the same brand.
Okay.
Then the third and final option is the compromise option that I was talking about. It's called cash and keep. That's where they give you cash compensation with you keeping the vehicle. It's basically because you overpaid for the product, so you should get some of your money back. If you get that, that settlement is confidential. It doesn't affect your warranty rights. And so when you go to trade out or sell, your vehicle is not tagged or labeled as a lemon.
Okay, and before I let you go, I know you've had this firm for 8 years, but you've been practicing far longer. So what is your firm's typical process for resolving such a claim?
Well, we have a 3-step out-of-court resolution process. We call it, it's kind of corny, but we call it our lemonade process.
I think that's a great name for it. Let's elaborate.
Well, I'm glad you like it.
Yes, I do love it.
So the first step is evaluation. Typically, somebody will find us online through Google, or they'll see a news story like this. They'll reach out to us. Then we'll ask them some background information about their vehicle. and we'll ask for them to send us what are called work orders or repair orders. That's the repair document showing the warranty work that's been done to the vehicle.
Okay.
Then, if we believe that the case qualifies, we will go over our out-of-court representation agreement. We always try and settle out of court. 95% of our cases do settle out of court. We want to avoid the hassle of litigation for our clients,
Certainly.
if at all possible. That makes it much quicker and easier. You never have to step foot in a courtroom.
Right.
And we can handle everything over phone and email. The second part of the process is the negotiation process. That's when we negotiate with the car company on behalf of the consumer. And we obviously will let the consumer know about offers and counteroffers. And as long as we're able to get the consumer what they want, then we reach the third step, which is the settlement step or the resolution step. And that's when we get, either the buyback, the new vehicle, or the compensation. So we try and make it as painless a process as possible. This is a process that's been developed over 20 years, so we've become very efficient at it.
And a 95% settlement rate outside of court, so you don't have to see the inside of a courtroom. Shalev, thank you so much. You guys, you can go to ArizonaLemonLawAdvocates.com for more details.